Please be seated. Good morning and welcome to Worthington High School. I'd like to take a moment to thank the administration, staff, and students from Adrian, Laverne, Southwest Christian, Ellsworth, Fulda, Windham, Slayton, and the Worthington ALC for being prompt this morning to help this event get started on time. At this time, it is my honor to introduce the Chief Justice, Chief Judge of the 5th Judicial District, Bradley Walker. Chief Judge Walker has served on Minnesota District Bench since 1998, and most recently as Chief Judge since 2013. He received his Bachelor of Arts degree from Gustavus Adolphus College and his Juris Doctorate from the University of Minnesota Law School. Prior to his tenure on the district court bench, he worked as an attorney in a private sector in Mankato for 21 years. Judge Walker also has significant military experience. He retired at the rank of Colonel in the United States Marine Corps Reserve. Currently, Judge Walker serves as a member of the Minnesota Judicial Council, the policy-making body from the Minnesota Judicial Branch. Please help me welcome Chief Judge Bradley Walker.
Thank you very much. I appreciate that. Everybody in the back hear me up in the corner there? Looks like it. Welcome to all you students from our host Worthington High School, as well as the faculty, the dignitaries, court staff who've joined us in the gymnasium this morning. And a special welcome to the students from Worthington ALC, Laverne High School, Adrian High School, Windham, Fulda, Slayton, MMC, Ellsworth, and Southwest Minnesota Christian High School, and the staff who've been able to accompany them. And I think some of you are watching the proceedings via either internet or ITV or television, so welcome to all of you as well. I've been told that many of you have been studying the court system and have had a chance to talk to attorneys, judges, and other staff members who have recently visited the school. But just for additional background, Minnesota's court system is over 150 years old, older than the state. The court system is divided basically into 3 levels. District court, where I work in Mankato, and that's where most of the cases begin. We handle everything from simple traffic tickets on the way to murder trials in the unfortunate circumstance that happens. There are 10 judicial districts in the state. This is the 5th Judicial District where Judge Moore and I serve. The next intermediate level of appellate court is the Court of Appeals. There are 19 judges who are hearing appeals from the district court for potential errors that we make or issues in law that they want to address. And then the Minnesota Supreme Court, which we're fortunate enough to visit with this morning, is Minnesota's highest court, the Chief Justice and the overall 7 justices on that court. Last year, Minnesota's courts handled 1.4 million filings. So it shows how busy everybody is. The Supreme Court, Minnesota's court of last resort, hears about 150 cases a year, depending on the numbers that they choose to review and accept. How does a case get to the Supreme Court? The Supreme Court hears appeals from the decisions of the Court of Appeals, which reviews district court decisions, and also the Workers' Compensation Court that is of appeals that's here in Minnesota, as well as the tax court. As far as automatic decisions, the Supreme Court hears appeals on all first-degree murder convictions directly from the district court, bypassing the Court of Appeals. And in the event there are certain unique circumstances like legislation or legislative election contest, that also is heard before the Supreme Court. A little background, if you don't know already, on the case that you're going to see argued today. It's the case of State of Minnesota, respondent, versus Roger Benedict Schmidt, the appellant. The appellant, Roger Schmidt, was convicted of violating a Minnesota statute. The statute provides that a person may not take a deer without a license. The Court of Appeal affirmed Schmidt's conviction, which happened at the trial court level, concluding that there was sufficient evidence to sustain it. On appeal to the Supreme Court, the issue that is presented is whether a person must acquire possession or control over a deer in order to take a deer in violation of the statute. This case originated in Stearns County in mid-Minnesota. Now, a few rules of decorum. This case you're going to see is a very real case. Very important matters are going to be decided today, and it's critical that the justices and the attorneys are not distracted. Therefore, we all ask you to abide by the same rules that you would if you visited the courthouse to see a case. Any activities that distracts from the court process will unfortunately be grounds for removal from the gymnasium. And please keep in mind, the total time for the oral arguments is about an hour. So we'll give everyone time to stretch right after the arguments are completed. So please make every effort to be quiet and respectful to the court, to the lawyers, and to the process. So I thank you very much for your attention and hopefully willingness to follow those rather minimal instructions. And at this time, we will ask that the court be convened in the Worthington High School gymnasium. Thank you, folks.
Good morning, please be seated. We have one case for argument this morning, Roger Schmidt versus the state of Minnesota. Mr. Flaherty, you've reserved 10 minutes for rebuttal.
That's correct, Your Honor.
You may proceed when you're ready.
Pardon me.
We're awake now.
May it please the court, Scott Flaherty with the law firm of Briggs & Morgan for appellant Roger Schmidt. We are all here today because the prosecution charged Mr. Schmidt under the wrong statute. He did not take a deer, but he was convicted of violating a statute that says no person may take a deer without a license. He did not take a deer on November 13th, 2011. This case should never have gone to a jury, which is why Mr. Schmidt moved to dismiss. But after the jury convicted him, he appealed, and the prosecution convinced the Court of Appeals to redefine the word take in a published decision that changed the law throughout the state. Effectively, the prosecution is taking a close enough is good enough approach to criminal convictions by trying to argue that take and taking are interchangeable in this case.
Well, counsel, when you say that the Court of Appeals changed the law throughout the state, didn't the O'Haron case in 1957 say specifically the statute's violated equally by attempting to take waterfowl or by actually killing waterfowl? So it didn't what the Court of Appeals do, hasn't that been the law of the state since 1957?
Your Honor, the quote you read from O'Haron is accurate, but that was not the rule of law that emerged from the O'Haron case. O'Haron identified the three arguments that the appellants in that case raised. Those arguments were narrowly targeted to whether specific intent was required on the concealment prong, insofar as whether a hunter needs to intend to be partially concealed or not. And the appellants, I believe the O'Haron case, I think it was page 83, called out those arguments. None of those three arguments challenged the definition of take versus taking. The fair reading of O'Haron is that that issue, whether or not take was defined by taking, was assumed without deciding. That doesn't appear to have been disputed by any of the parties to that case.
So what is the status of what you would call dicta in terms of take versus taking in O'Haron?
Well, in O'Haron, it's not entirely accurate to call that statement from O'Haron dicta because it was used in the chain of reasoning for the court to reach its result. But it also appears clear that that issue wasn't argued by the parties. So I think the only way to characterize O'Haron is that it was assumed without deciding. And O'Haron didn't call out and say, we're assuming without deciding that take and taking are interchangeable. But functionally, that's what the case did. And of course, this court has a long history of not deciding issues that weren't raised before it. And as best we can tell from the opinion, the three arguments raised in O'Haron did not challenge that definition of take. The defendants there chose to focus their argument on that partial concealment prong. And so O'Haron is good law, doesn't need to be overruled because that statement was not disputed by the parties there. And we know that O'Haron didn't define taking throughout the Fish and Game laws in Minnesota because no court in Minnesota has ever cited O'Haron for that proposition. The Court of Appeals didn't in this case. It didn't appear to be aware of O'Haron. And so O'Haron is not a case that defined the meaning of the word take throughout the Fish and Game laws, even though it is a case that did use the word take and used the word taking to replace it. That was not the holding of the
Counsel,
case.
I'd like to just spend a few seconds on your discussion of early English common law. The challenge has been made by opposing counsel that we should ignore that common law for a variety of reasons, but most particular that because those cases dealt with property rights, and this of course is a criminal prosecution, and so therefore we shouldn't be importing those several hundred-year-old cases. How do you respond to that?
Well, this case actually is about property. The Minnesota statutes explain that the state of Minnesota owns the wildlife in Minnesota unless and until someone legally takes an animal. And only if a legal take occurs does a person acquire property rights in an animal. So that's the first response. And there's a second one. Throughout the Fish and Game laws and the DNR rules, there are restitution provisions for when someone does deprive the state of that property. The DNR can require that that person pay restitution to the state for the loss of that property. Wild animals are always about property, as are other crimes. If theft occurs, I mean, that's a crime about property, and we may look to English law to inform what should happen in that case. So the fact that this involves property and the fact that it's a criminal case, those two are not in tension at all.
Counsel, if you could turn to the text of 301. It seems to me, I'm interested in your textual argument. The word take and taking are used in the statute. Why wouldn't that support the proposition that the legislature intended the two words to be synonymous? And after all, take is the root of taking.
Your Honor is absolutely correct that take is the root of taking, but the presumption of consistent usage, a canon discussed in the briefs that this court has discussed elsewhere, holds that where two different words are used, they are not presumed to have the same meaning. And so the fact that the legislature in 97B 301 chose to use take in some places and taking in other shows that the legislature understood those words to have a different meaning, and they've used them differently throughout the Fish and Game laws. The legislature.
I guess what I'm trying to drill down is take is the root of taking. Why would they? I mean, I guess from a common sense perspective, it seems to me that the legislature was intending to regulate the taking of a deer, a duck, a pheasant, whatever. And it just seems illogical to me that it's only the act of actually capturing or killing the deer, the duck, or the pheasant that is the only thing that's regulated. I suppose that would be, I mean, there would be several thousand people in Minnesota that would not have to have licenses if that were the case.
Well, to respond to your question, Your Honor, you're on to, I think, an important insight, which is that the legislature has regulated taking, a word broadly defined by the legislature to include all parts of the hunt. And in some parts of the Fish and Game laws, the legislature does use the word taking to show that they are referring to everything, all parts of the hunt. But in other parts of the statute, including the statute here that Mr. Schmidt was convicted under, the legislature wants to be more precise. Sometimes the legislature wants to refer to all parts of the hunt. Other times, the legislature wants to refer to a take. And when the legislature does that, it uses the word take, and when it wants to regulate more broader activities, then it uses the word taking. So by having maintaining the different definition of the two words gives the legislature the ability to do both when it wants to focus on the take, for example, in the context of restitution. If an animal is taken, the legislature may want to ensure that the state gets compensation for that.
So is your suggestion that in 301 sub 1, if the legislature had intended what resulted here, it would read, a person may not taking deer without a license? That seems to have an air of unreality to it.
That would be ungrammatical, Your Honor, and in fact, that shows why these two words are not interchangeable, because plugging taking into this law makes nonsense. But what the legislature could have written, it could have written taking a deer without a license is a crime. And in fact, that sentence has only 8 words, but the sentence the legislature actually wrote here has 10. So the legislature went out of their way to write a more precise statute. Of course, they could have simply written something shorter that would have captured broader conduct. But we have evidence that we know of the reason they didn't do that, and that goes to the criminal attempt statute. When the legislature revised the criminal code, the advisory committee that the legislature assembled put in
Let's just stick with the plain text, and to follow up with Justice Page's question, in subdivision 4, the title is taking, and then there are several occasions in subdivision 4 where taking is mentioned. It's also mentioned in subdivision 6. Why is it that we should conclude that subdivision 1, the legislature intended to use take in a different sense than taking in these subdivisions 4 and 7?
The response is because the legislature chose a different word. The legislature could have used the word taking throughout. This statute could be rewritten to capture slightly different conduct.
But counsel, here's the problem with your argument. I've looked back at the cases on the consistent usage canon, and we don't apply it, and I haven't found courts that apply it where you have a root form of the same word. Usually when that consistent usage canon is applied, you have 2 different words that are synonyms, or potentially synonyms. Can you find any cases where that canon actually applies in the context of 2 words that are essentially different tenses of each other?
We did not find such a case, Your Honor, and so if that were the only canon that supported our argument, we'd be in a more difficult position than we are. But that canon is reinforced by other canons here, including the presumption that the legislature acts with knowledge of the common law meaning of terms. So that's take has a common law meaning, and that is why the legislature defined taking, because it left intact, effect, the definition of take, and it chose a different word, taking, to refer to, again, all parts of the hunt. So the legislature chose to keep for itself its ability to focus on the precise narrow act or to focus on all parts of the hunt.
Counsel, let me ask you a hypothetical question. Let's say I'm out hunting deer, excuse me, don't have a license, take my rifle, I see a deer, I shoot, I just graze the deer. No significant wound, the deer looks at me, walks away. Have I violated the statute? Have I taken a deer without a license?
You have not taken a deer without a license if you didn't acquire possession or control of it. So as far as the statute, you didn't violate subdivision 1 of 97B 301. Some of the DNR rules, and I don't have a cite off the top of my head, speak to injuring an animal in the context of restitution. So whether or not you violated this statute doesn't mean you didn't violate some rule or some other statute or owe the state something for what you did.
Well, let's now assume that I hit the deer, I think it's a mortal wound, but I don't know, the deer goes off and I can't find the deer. Have I violated the statute?
Again, if you haven't acquired possession or control of the deer, no. If the DNR, this statute, as far as other rules, it's a little less clear. But this statute requires a person to take a deer. If you shoot a deer and it goes off and you never find it, if you were to return to the hunting lodge and tell the rest of us what you'd done, I don't think any of us would believe you'd taken the deer.
We might not believe he shot it either.
Counsel, do I understand your position to be a legal position? In other words, if we get to the issue of whether or not the evidence is sufficient to support the claim that your client was in the act of taking, let's say we determine that the words are synonymous, that the evidence is sufficient to support that. In other words, what I'm getting at is your position is take means possession or control, therefore as a matter of law, there's no violation. So in other words, these peripheral facts are no longer relevant.
So the question is, I want to make sure I understand your question, if the court concludes that take and taking are interchangeable, then what happens? Is that the essence of the question?
Correct. Yes.
So then I think that the answer to your question is no, actually. This goes to the distinction and opinion between what the Court of Appeals ruled and what the trial court ruled. The Court of Appeals decision, the one on review here, walked through all of the possible different meanings of pursue, and in effect concluded that sitting in a field armed wearing blaze orange is pursuing a deer. That's also error, but that's a different mistake than equating take and taking on the other side. Of course, that goes to the example in our brief of the moose hunter. If someone is out in a field with a gun sufficient to fell big game and they have a moose license, if we equate take and taking, that person is going to be guilty of illegally taking deer. Even if they have a moose license, it wouldn't be a defense to this statute to say I have a license to hunt some other animal that also may be in the area. And that's one of the problems created by the Court of Appeals decision. Is unless
I guess what I'm trying to take off the table, if I'm understanding your argument, is that if we conclude that take and taking are synonymous, isn't it the evidence sufficient to support the conviction?
And the response to that is no, under either the Court of Appeals or the District Court's theory. Under the Court of Appeals theory, the pursuing theory fails for the reasons I just explained. And as far as the District Court's theory, attempting to take, I think the jury there didn't receive any specific intent instruction that would have been required under an attempt offense.
But there was no objection to the instructions, right?
I believe that is correct, Your Honor, yes.
Counsel, in Chapter 645, the legislature has told us that when we're interpreting statutes, we're to apply the rules of grammar. Are there any rules of grammar that can help us decide whether the definition of taking applies to the word take?
Yes, there are. So as used in this statute, let's start with the word take. This statute's plainly written, a person may not take a deer without a license. The part of speech there in that statute that is take is only a verb. It's a verb, that's the end of it. The definition of taking in the Fish and Game laws doesn't specify what part of speech the word taking is. It says taking means, and then it has a list of words. So taking can be used as a verb or can be used as a noun. It's grammatically broader than take as used in this statute. So that shows that the words are not interchangeable. So the grammar presumption instructs us that take as used here is not the same as taking defined elsewhere in the Fish and Game laws.
Counsel, let's try that analysis of grammar in a related statute. Minnesota law prohibits hunters, says you may not take a deer when you're under the influence of alcohol. Do you think the legislature meant that you can get drunk and shoot at deer, but as long as you don't hit them, then you haven't committed the crime?
As far as that section of the crime, that's correct, which is why that statute was amended in the late 90s to add a different provision that criminalized being drunk while in the field armed. So the legislature recognized that it's a different crime to take a deer while intoxicated than simply hunting while intoxicated. But of course, the solution to any potential dilemma there is to charge this drunk shooter with criminal attempt. That would be the proper way.
Good response. Let's try another one. The legislature says you may not take deer from a platform higher than 16 feet. Do you think the legislature intended you could build a a high deer stand and shoot a deer, but as long as you didn't hit one, you could do that?
So if you don't hit one, you haven't taken a deer from any platform at all. And again, the solution is to charge that person with attempt. Or, of course, the commissioner can write a rule that would say taking deer from a platform higher than 16 feet is a crime. That would be...
Well, the commissioner can't write a rule that's broader than the statute, can he?
The commissioner can write different rules in the statute, yes, including broader. The commissioner's rule writing authority isn't constrained by the statutes the legislature has passed. We talked about the grammar canon a moment ago. There are other canons that support our reading of the statute. One is the associated words canon. The section 97A 301, which is the general penalty provision of the Fish and Game laws, it uses the phrase takes, buys, sells, transports, and possesses. That's one example of where this associated words canon tells us that if we're interpreting the word take, these other words that are its neighbors in the statute all connote possession, buying something, selling something, transport. In fact, the word possession is there. These words can be substituted in the statute that Mr. Schmidt was convicted of, in fact. Unlike the word taking, where Justice Page recognized that if we plug that word in, the sentence doesn't make sense, we can plug in a word like buys and sells. A person may not sell a deer without a license. That's grammatical. A person may not possess a deer without a license. A person may not transport a deer without a license. The other words that involve possession or control can be substituted into that statute, and that's why the associated words canon also supports our reasoning. And then, of course, there's the rule of lenity, which tells us that if there is ambiguity in a criminal statute, at some stage of construction, that ambiguity should run in favor of the defendant, because criminal defendants and people accused of crimes have the right to fair notice of whether or not their conduct will violate the law. Here, we submit, again, this statute could not have been written more plainly. A person may not take a deer without a license. And if the legislature had wanted to write a broader statute, they could have used 8 words in taking, and they could have written an even shorter one. From what the legislature did, they wanted to capture that precision, and that's why they chose to use the word take. This court's case law makes clear that we don't assume the legislature makes mistakes when it writes statutes. We assume the legislature knew what they were doing. The legislature defined taking in the Fish and Game laws by statute. And even though they defined it, in this statute, they didn't use it. It's not in that first sentence of subdivision 1. It does appear in the headings, as Justice Dietzen mentioned, but of course section 645-49 tells this court that the headings are not part of the text of statutes. So
Counsel, let me ask you about the rule of lenity. The question I have is how it would operate in this particular case. We have case law that suggests, Peck being one of them, and there's a number of other cases that says when a statute is ambiguous and you apply the rule of lenity, the court is required, it's not optional, it's required to pick the most pro-defendant friendly interpretation. You argue that that should work side by side with all of these other canons, but how can it work side by side when our case law suggests that we have to pick the most, in other words, it trumps every other canon because we have to pick the most pro-defendant friendly interpretation?
So there is case law from this court suggesting that it is a trumping canon, so to speak. But not all of this court's cases hold that, and there are a lot of cases, the Leathers case comes to mind, where the rule of lenity is applied side by side with other canons. There it was in pari materia. The wiser rule, to the extent there is competing lines of cases from this court, is to treat lenity like all the other canons. These are all canons of construction, and no canon consistently trumps the other.
But how would you do that in a situation, take Leathers for example, say in pari materia goes the other way. It goes towards the state's interpretation. Rule of lenity obviously goes towards the defendant's interpretation. With Peck out there and some of the other cases, wouldn't we have to pick the most pro-defendant friendly interpretation no matter what the other canons say?
If Peck is being followed, the answer is yes. But I think the point to recognize is that Peck is one case among many talking about how the rule of lenity applies in this court's jurisprudence. And so if Peck is followed, then that's the outcome. The better outcome seems to be treating all canons equally. But this case isn't really, I think, the proper vehicle to resolve that competing dispute, because all the canons raised by all the parties favor defendants here. So we don't have a situation here where grammar points one way and lenity points another. All the canons point together, and that's why in our brief we suggest that this case may be appropriate to recognize some competing lines of authority in this court's jurisprudence, but this case can be decided without resorting to lenity. This court could consider 1, 2, 3, the other canons that we've talked about in the briefs, and simply resolve the ambiguity on that basis. I'm not aware of any precedent that requires a court to consider all possible canons when deciding a case. The court can say, these 3 canons are most persuasive here, those are the 3 we're going to rely on, and this is why we reached that outcome. So I think that's the best response, because lenity is a thorny issue, and as has been briefed, how lenity applies under federal law does not appear to cleanly match up with how lenity applies under state law. And of course, this court is the final authority in interpreting of state laws, and so what the U.S. Supreme Court does with lenity does not bind this court in terms of lenity under state law.
Counsel, before you move on, I want to just make sure I understand your argument. With respect to subdivision 47, taking, I want to ask you about pursuing and shooting. Do you agree or disagree that those terms aren't necessarily limited to acquire possession or control? In other words, a hunter can pursue a deer without acquiring or possessing. A shooter or a hunter can shoot a deer without acquiring possession or control.
Yes, Your Honor, and in fact, most hunters probably do pursue without ever acquiring possession or control, and certainly some do. So again, pursuing and all of those words used within taking are for, again, allows the legislature to reserve for itself a word that captures the breadth of the hunt, all parts from the beginning to end. And that's why we see the statute that gives the power to the DNR commissioner to regulate taking of animals, because the DNR is not limited to regulating the act of the take. The DNR can regulate the preparation, the beginning, post-take activity canon is regulated by the DNR. So pursuing is one of those things that the legislature can regulate and the DNR can regulate and doesn't require a completed take.
Counsel, you began your argument by suggesting that the defendant here was charged under the wrong statute. Now, maybe I missed this, entirely possible, but is it then your argument he should have been charged under some other statute?
If we believe the state's theory of the case, he should have been charged under 609-17, the criminal attempt statute. The state's argued repeatedly that Schmid was attempting to take a deer, and of course that language appears in taking. If that's true, if we believe that he was attempting to take a deer, then he should have been charged with criminal attempt, and the state would have had to prove specific intent, which is required under 609-17. The state short-circuited that procedural protection for the defendant here. By convincing the trial judge to equate take and taking, the state didn't have to prove specific intent. They got to prove effectively a completed attempt, even though the conduct at best supported a simple attempt, not the completed crime. And so that's again why this is such an important case for criminal defense protections. Every citizen in Minnesota, even citizens accused of crimes, are entitled to be charged under the right statute that fits the allegations against them.
So you would say that, looking at the picture broader than just this particular case, this case doesn't have any implications for the game and fish laws of the state of Minnesota as long as the state charges, in other words, the state can still charge criminal attempt in the sense that this doesn't cut a hole in the game and fish statutes. Is that right?
Correct, Your Honor. A decision in this case is not going to legalize poaching statewide. What it will do and should do is inform prosecutors that if a take doesn't occur, a defendant hasn't violated a statute that requires a take. You charge it as attempt, and of course the DNR, the commissioner of the DNR, writes rules and can continue to write rules to capture specific conduct. But a decision in this case shouldn't radically alter the fish and game laws, except insofar as the following. This court hasn't ever held squarely stated that take is a legal term of art that means the acquisition of possession or control. That change, that clarification, can and should come from the court's decision in this case. But again, that holding is not going to rewrite the fish and game laws. It's not going to cast our state's hunting system into chaos.
Thank you, counsel. Your time has expired. You have 10 minutes for rebuttal.
Thank you, Your Honor.
Mr. Tweeden.
May it please, tried to avoid that. May it please the court, counsel. My name is Ole Tweed, and I represent the respondent state of Minnesota. I appreciate the court's questions to appellant. I agree with many of them. I believe that the evidence is very clear that what Mr. Schmidt did was attempt to kill a deer that day. I did not hear a precise answer to the court's question as to whether or not this would be insufficient evidence or not, but I think it's very clear that there is sufficient evidence that if this court defines take under the definition of taking, he absolutely was taking the deer. He was pursuing a deer consistent with the analysis in the Court of Appeals.
Let's start with the last question first, which is why wasn't this charged as a criminal attempt rather, and isn't that what's really going on here, and shouldn't that be the way this case was charged?
Thank you, Your Honor. I don't believe it should be charged that way, and partly there was no guidance for the prosecutor in our situation to charge a criminal attempt outside of the 97A through 97C scheme, especially when you have a definition of taking, which includes the term attempting to take. State v. Ritter at the lower court, the Court of Appeals, has a published decision where this court denied review in 1992, where the state did try to get into specific intent and attempt to approve up an attempt under the criminal type of statute. That was denied. The Court of Appeals, I believe it was Judge Klopacki, and two other judges unanimously decided that this is not an attempt in a criminal statute. That's not appropriate here. And part of the analysis limiting those facts to a non-attempt to hunt was that you had to look back under principle, and I may butcher the Latin term, adjudum generis, when you had to look back to the preceding words in the taking definition. Had that not been true, had the word take in the hunting under the influence statute, had that meant something different, like appellant's proposition that it means acquire, possession, or control, they could have charged attempt to take under the criminal statute, and then it would be a substantial step towards that take, acquiring, possession, or control, and they would not be necessarily limited by those other words in the definition of taking, because appellant, as they've said, believes that that has no applicability here.
Well, counsel, let me ask you a variation. I'm not sure it's the consistent usage canon, but just a matter of plain textualism, reading the statute. When the legislature uses two different forms of the same word, particularly one that's a noun and one that's a verb, you have a situation where there might be a different interpretation. So why shouldn't we go with the common law interpretation, given that we don't have an explicit definition of the word take in the statute?
Thank you, Your Honor. When you talked about earlier about the root term, basically taking deriving out of the word take, you don't have a definition of take, it cuts both ways. Appellant has said that this legislature has defined numerous things, and in their brief, highly regulated area. They've defined taking but not take. If take was so simple, to acquire, possession, and control, and they meant to mean something different here in the text, why not define it? In fact, they even define the term deer, white-tailed or mule deer. That is a common term. Certainly you could find the common usage of that, use the plain meaning of that. Here, there's no suggestion throughout the history that take or the regulations related to what's at issue here were limited only to the acquiring, possession, or control. I will concede, as in the state's and appellant's or respondent's brief, that there were terms take, kill, or pursue with the intent to kill, dating back all the way to 1895, 1905 statutes. But those statutes all included something above and beyond take. So it's unsurprising that they use the term take interchangeably with other like words throughout the statutes. And that's what the state's arguing here. They wouldn't use take and separately use taking if they are being as explicit and intentional as appellant says, without defining the term take as something else. They wouldn't rely only on the common law, especially in the face of jurisprudence from this court, whether that was the precise issue or not. But in O'Haran, they certainly say, take, to determine what take is, we need to determine what taking is. It's essential to the opinion. It's quoted in its entirety, the term taking. They never separately define take. Certainly there's not a difference of opinion suggested by that appellant, but there's a statutory construction argument there. So how would the legislature, knowing after 1957 that they've got a problem here if they're trying to legislate this, or if they're not, as appellant suggests, that they're only trying to legislate against acquiring, possession, or control, Why would they not then change post-Heron that definition or make it explicit that take means acquire, possession, or control, taking means something broader, and when we speak differently, we mean different things. And when you know, it says a person may not take deer without a license, 9 words rather than 10 versus 8, I don't think the difference matters, but may not take deer. It doesn't say may not take a deer, a single deer, multiple deer. It says may not take deer. That can mean multiple things. That can mean take deer, the process of taking.
Counsel, let's explore the implications of your argument that take essentially means pursue and taking means pursuing. Let's say some morning I decide I want to go out and take some pictures of deer. So I grab my camera and I go up a deer trail and I'm stalking a deer. Am I pursuing a deer, and have I just violated the statute where I can't pursue deer without a license?
No, Your Honor, because there is a context to that word pursue. The pursue is in taking in a statute that also defines hunting as taking birds or mammals. That pursue is defined by the words around it: shooting, killing, snaring, netting. You have pursued it for a different purpose. You have pursued it to take photos of it and nothing more.
But the statute's not limited in that way, is it? It doesn't use the word hunting. It simply says you may not take deer without a license. And your argument is take means pursue, so why am I not committing a crime?
My argument is take means pursue and all the other terms that are listed in taking. And if this was a statutory construction argument about that case, I would be standing here sheepishly and losing, because it wouldn't make any sense to use the term pursue for photograph without the context of hunting type activities that are around it.
Yeah, but the definition of taking does not, in the statute, does not include the word hunting. It just says pursuing. Now, it does say shooting, killing, capturing, trapping, snaring, etc., but Mr. Schmidt didn't do any of those things, did he?
No, he did not, but when you look at what pursue means, pursue can only mean pursue to do one of the other types of things.
Well, what if it's a situation where I buy land and I put food out there? I mean, it's a woody area. I put food out there because I'm trying to get the deer to come. I build a deer stand. And I mean, that's the whole point of it. It's hunting land. That's the whole reason it's there. I mean, is that pursuing? Is that person who buys land and puts food out to attract the deer and getting all ready for the hunting season to open up? I mean, are they pursuing?
If you build a stand in the sense that you're building the stand and put food out there for the deer so that they're there when hunting season opens up, then yes, you are pursuing under the meaning of the statute.
So you need a license to do that?
You do. The statute says may not take deer without a license. So you may not pursue that deer without a license. Simply putting...
So under the state's view, if I buy land out in the country, and I mean, in my hypothetical, I do all of that, and the deer are coming, but I never get up in the stand with a rifle, I'm still guilty of a crime?
You may be. We may not be able to prove it because we wouldn't have the evidence that, in this case, on these facts, where he clearly was out hunting, whether hunting's listed or not. He clearly had the shotgun. He clearly was out afield. You wouldn't be necessarily caught doing that. The DNR, and part of the problem with limiting this ability to regulate, the DNR doesn't have the ability to go look for people who don't have shotguns on their person, who are simply out in their own land, afield in their own field. And there may be certain regulations that allow certain things like that beforehand that I don't have on the tip of my tongue.
Well, doesn't the chief's hypothetical raise sort of a slippery slope? I mean, perhaps the landowner is setting this up so that other people can hunt on the land. He or she has no intention of hunting themselves. And I think your argument would be that case would have to go to a jury because there's enough there, in building the stand and putting the food out to constitute pursuing. Is that a good rule, or am I missing something there?
And maybe my answer was a little too broad, because when you look back at the preparatory language, the state would have to get around Ritter and the preparatory to hunting language, where a person was all the way out at the side of a road in a published decision, had a gun, unloaded, but had a shotgun, was talking about being hunting, and was intoxicated. And they did not find that that was pursuit because it was merely preparatory. And perhaps that language would limit the state to do any of the things that the Chief Justice suggested. And I think that actually is a good point by both the Chief Justice and Your Honor to say there is some limitation there, and there still can be with the state's definition taken out of 97A015.
Let's go back to what I think we all agree is really our only serious look at this question in O'Hearn. And we heard the argument by opposing counsel that what was going on there is assuming without deciding, and that the language that I believe was read by Justice Lillehog does not speak directly to our circumstance here. In other words, it's not a binding holding. Do you agree or disagree with that analysis, and why or why not?
I disagree that it's a binding and it's not a binding analysis. It is not the precise holding, but to get to their holding, they must have determined what take meant.
But he says the reason, and he I think agrees with that, but he says that that's because that issue wasn't squarely presented there, and they're assuming without deciding it. He describes it as the chain of reasoning. Why is he wrong about that?
He may not be wrong that it's not the chain of reasoning, but it becomes something more than dicta, which he did concede. It becomes the court's analysis. It is not the holding in the sense that they are not saying take means taking because your separate definition of acquiring possession and control is wrong. They are simply not saying the exact same thing. However, there's no way to divorce their reasoning from the analysis this court should do in this case, and more importantly, what the legislature is supposed to do to respond. They have no other way to respond other than to take the court at its word is, this is what the court believes these statutes mean, and has interpreted them as such.
Why shouldn't we, in a criminal statute, why shouldn't we say to the legislature, we're not going to engage in all the gymnastics we have to engage in to get to the interpretation the state prefers here? We'll just take at the language, at the meaning of what it has meant for several hundred years, whether it's in a property context or not. And if the legislature thinks otherwise, they can change the statute to make it a non-mens rea, non-specific intent type of crime.
Your Honor, the legislature has given you the statute that requires this court to ascertain and effectuate the intent of the legislature. And you have the whole body of law out there around this concept of take, pursue with intent to kill, hunt, using words interchangeably. I believe it's Justice Lillehog in Nelson's who stated that it's a grievous ambiguity is the only time you apply the rule of lenity. That principle is important for any type of statutory construction. When you're trying to find the legislature's intent, rather than simply saying, we've got to throw up our hands, there has to be a reason to throw up those hands. And that's when the rule of lenity comes into play, when there is a grievous ambiguity. And based on the comment, it may have been Justice Strauss in the majority opinion who actually used that language. And I see nodding head, so I apologize for that. But certainly we need to figure out what the legislature meant. And when you look back at the history, it's very clear what the legislature meant. They meant more than just acquiring possession or control, and they wouldn't have used the word take throughout all the statutes interchangeably with the word taking. And I believe it was Justice Deason's point earlier when we look at 97B.301, and Justice Page followed up on this. Subdivision 1 is licenses required, the statute at issue. But Subdivision 4, taking more than one deer, what allows you to take that second deer, the statute specifically says, Commissioner may by rule allow a person to take more than one deer. However, the Commissioner shall prescribe the conditions for taking the additional deer, including taking by firearms, muzzleloader, or archery. Does that make sense?
Counsel, can I, as long as we're talking about the statute, and Subdivision 47 is what I'm interested in, I'm concerned that the state's position regarding pursuing is quite broad. And I'd like you to tell me what your position is exactly in terms of what you think pursuing means under that, under Subdivision 47. And I'll give you an example. If I, during deer hunting season, wear my blaze orange, do I need, on a field, do I need a hunting license?
No, because that's not enough facts that you were pursuing deer in the meaning of the statute.
How about if I'm wearing my blaze orange coat and I've got a loaded shotgun? Is that enough? In other words, what exactly is pursuing a deer? I can walk across the field in blaze orange during hunting season so someone doesn't shoot at me. I could be intending to go for a nice walk in the woods, and I might be concerned about coyotes in the area. Why is that? Is it your position that that would be, in and of itself, is enough to trigger the statute pursuing a deer and require a deer license, and therefore I could be charged and convicted?
It's not my position, Your Honor, and the facts of this case, you don't have to necessarily get to that issue because the facts of this case are above and beyond, well above and beyond that scenario. Clearly here he was...
What I'm trying to get at is, what is your rule of law of what pursuing means?
Thank you, Your Honor. Although it's context specific, the rule of law is pursuing would be a field in a deer hunting area, more than mere preparatory as decided by the Court of Appeals in Ritter. A field acting as though one is hunting. And the way you could prove that up is how they are dressed, how they are located, what their statements are, what their stated intent was, who they are with, what part of the field are they in, what are they wearing, what type of weapon, if any, do they have? Do they have a license that's expired, as in this case? It is, like any crime, it's essentially context specific. There are certain things that cannot be because of Ritter, and this court can write in that pursuit must mean something more than mere preparatory to hunting, just like Ritter is, essentially adopting the position of Ritter, and that would be appropriate. That would certainly cover the acts that many of the justices here have questioned. It certainly doesn't make any sense if there's no other evidence that an individual is simply walking around in blaze orange that they are pursuing deer.
So connect those facts that are present here to your definition as you've walked it through with Justice Dietzen, please.
Thank you, Justice. A person who is a field in a deer or other type of hunting area, whatever the appropriate season and field is, a person who is a field in that area armed and commonly known as in pursuit of deer. That's using the term twice, but it is looking for, attempting to locate, attempting to intercept, and any other of the other commonly known terms of pursuit that are used by Judge Ross in the lower court. All of those factors come into play and establish a pursuit in this context. It has to be something tied to shooting, killing, catching, snaring.
Counsel, is the bottom line in answer to Justice Wright's question that you can't hunt deer without a license? And in that regard, if you go to subdivision 26 of the definitions, doesn't it say hunting means taking birds and mammals?
In essence, yes, and in essence that ends up being circular, but it's similar to the context of these same types of statutes where before they took the definition of hunting from its long definition, which was consistent with taking, and narrowed it down to simply say hunting means taking birds and mammals. Before they had that, they were almost identical definitions. They were used interchangeably throughout, and then the terms hunt and take were used in the same statutes.
So the prosecution needs to prove beyond a reasonable doubt that the facts, whatever they are, show that Mr. Schmidt was hunting deer.
Correct. Through pursuit, shooting, killing, shooting at. Any of those things would be hunting deer. And I think that's probably a much more concise version of what I was trying to get at. So I appreciate that. I would like to turn to the rule of lenity, if I may, and discuss some concerns I have with appellant's analysis. And I do believe that Justice Strauss is correct that this has to be a lenity-last approach. Certainly you don't have to go through the minutia of each and every canon, and I agree with the appellant on that. It wouldn't make sense in many contexts to go through every canon. But it's only when you have that grievous ambiguity, when you cannot determine from two or more reasonable interpretations which one is the most reasonable, then it certainly makes sense to apply the rule of lenity. It doesn't make sense in this case. No hunter would think that they can go out and shoot at a deer, miss it without a license, and not be charged, but be charged if they shoot, hit it, and then go up to it and acquire possession or control. No hunter would not be on notice based on the definition of taking that doesn't apply to take. No hunter would look back to Pearson v. Post in the common law and say, you know what, I've got an out here, I'm going to go out to the field, I'm going to do some conduct that's only intent is to acquire possession or control, I won't have a license. I'll essentially attempt to poach, but only be in trouble if I do poach. That doesn't make common sense, and it isn't what the rule of lenity is for. And so I think this is a good vehicle for the court to clearly say the rule of lenity should be last. Now, certainly
But on the facts here, we don't have any evidence of shooting, do we?
we do not. We do not, Justice, and certainly we don't have.
All we've got is evidence that he's in the field with the gun, with the mobile blind, if you will.
Yep, we do, and we have evidence that he's out there in the area where he had just shot a deer the night before, where he's seen deer. We have his words as to what he's doing, and in some statements he makes to the DNR officer, which the jury had to have believed to have convicted him, he says that he was party hunting. He says he was out hunting. We don't have the concern that I mentioned in terms of the rule of lenity, but we know that he was out hunting, looking to complete that. He even says he was. He doesn't have the exemption that he tries to tell the officer what it is. He says later at trial that he was just out waiting to retrieve the deer, but the jury had to have rejected that to convict him. What we have is the evidence in this case is he lied about what he was doing out there because he was out hunting again. And because he does that, it doesn't necessarily matter that he didn't fire at a deer. It's important because the way he was caught is likely the common way they're going to catch someone, either in the act of hunting pre-killing the deer or only after killing the deer if they're near and possessing the deer. You're not going to be able to find someone in that immediate act of shooting or in that immediate act of acquiring possession or control. Essentially, determining take, the way appellant asks you to, means you can find someone, they might as well have written possessed. Because if you possess deer without a license out in the field, you've taken that deer in the meaning that appellant wants. But they mean something more. They mean the concept of to take deer. They mean the taking of deer throughout that process. Once it starts, acts more than mere preparatory to hunting, throughout the successful, what every hunter's intent is, for the most part, is to kill that deer and acquire possession or control over it. So I don't believe that the rule of lenity is applicable to this case or should be applied to this case. Certainly if you apply it, it's not a two-way street. If you apply it, the state's going to lose, because the only reason to apply it is if you think there's a grievous ambiguity. I don't have another way to get around it, because once you've applied it, the case is over. You can't say the rule of lenity, well, they don't really have notice of what's happening here, but we're too bad for them. That doesn't make much sense. It's certainly an important rule, but that's part of the reason, because it almost always, if not always, is going to decide the case above and beyond any other statutory or use of canons to construe the statute. So I encourage this court, I ask this court not to apply the rule of lenity here, to determine that it applies after this construction, and first to find that there isn't ambiguity. The definition controls. Definition of taking controls. He was out there hunting. He was attempting to take deer. They caught him before that. That's what the legislature designed this word for. That's why they use take in subdivision 1 and taking interchangeably in subdivision 4. It wouldn't make sense in 97B.301 for them to use, the legislature to use the term take for the first kill, the first time you're out there hunting, up until you acquire possession and control. But then after that, for that second hunt, when you get that bonus permit, to then regulate the taking of the deer, to take the whole second hunt. That doesn't make any sense, and those two subdivisions cannot possibly be read together as intentional as appellant has asked this court to do. And if there are no other questions, I'd ask the court to affirm the Court of Appeals. Thank you.
Thank you, counsel. Mr. Flaherty, you have 10 minutes for rebuttal.
I'll leave it. Thank you, Your Honor. There's one rule of law that can emerge from this case that solves every single hypothetical that's been discussed today. And that's by holding that when someone is illegally hunting but doesn't take a deer, the state's required to prove criminal attempt. That would allow Justice Lillehaug to say, I wasn't intending to hunt, I didn't have that specific intent, because of course I have a camera, and his camera is evidence that he's not hunting. We don't have to torture the definition of pursuing and twist take upward to expand extra conduct, but then contract the definition of taking so that pursuing isn't absurd. We can say the legislature used the word take, and it did so deliberately. We know it did so deliberately. We can look at other parts of 97B 301. Justice Dietzen, when I was up here before, mentioned subdivision 4, which discusses, allows the commissioner to, quote, prescribe the conditions for taking the additional deer. And then it has a list of 4 items, and at the bottom of the list, the legislature wrote, the total number of deer that an individual may take. Adopting the state's reading here would make subdivision 4, would be instructing the DNR commissioner to limit the number of deer that may be pursued. That's absurd. A hunter in Minnesota who has a valid license can pursue as many deer as he likes. He may only take one. If you have a bonus permit, he can take a second one. But he can pursue as many as he likes. That goes to the grouse hunting example from Rule 6234-0300 in the brief. That says a person may not take more than 3 sharp-tailed grouse per day. If I'm out hunting grouse and I know there's a group over in the bushes, and I flush the group, and I flush the group, there's 4. Seeing there's 4, I know I can only take 3. I don't even shoot at a single one. Under the state's definition, I've now pursued 4, and I've committed a crime simply by approaching a bush with grouse in it. Those types of examples abound throughout the fish and game laws and rules if we adopt the state's reading.
Counsel, speaking of fish and game, let's see if there can be any kind of analogy here to fishing. And I would direct your attention to the set of definitions in 97A015. Subdivision 2 contains the definition of angling or fishing. Angling means taking fish with a hook and line. An angler is a person who takes fish by angling. Now that seems to equate taking and takes. If I am out in a boat and I have a rod and reel, a line with a hook and a worm on it, am I in the act of taking fish? Or
Yes.
do I need to catch a fish before I take a fish?
Both. So if you have your line in the water baited, you are engaged in the conduct of taking fish. Because again, taking broadly defined. But under this definition, it requires an angler. I read the second half of subdivision 2 a little more narrowly than that. It does say an angler is a person who takes a fish by angling.
Okay, so I'm not an angler till I actually catch a fish?
No, the converse of that. If you catch a fish, you are an angler. But I don't read this definition as excluding the common sense notion that someone who is fishing is an angler. It doesn't say that. That's true.
So someone who is hunting is a hunter?
I think I would agree with that proposition.
So I can be a hunter even though I haven't shot anything?
Yes.
All right. And then when you take a look at the definition of hunting in subdivision 26, hunting means taking birds or mammals. Why shouldn't we construe angling and hunting the same way and use the word take and taking in the same manner?
Well, it's telling in subdivision 26 that it doesn't have a second sentence that parallels the second sentence of subdivision 2. The legislature didn't write in subdivision 6 that a hunter is a person who takes an animal.
Yeah, but would it be logical for the legislature to have one rule for hunting and one rule for fishing in terms of whether you're actually taking game or fish?
That doesn't seem obviously logical to me, but we know it's what they did here. They could have written parallel definitions, but they didn't. There's a reason that second sentence is missing from the definition of hunting. It's present in angling and it's not in hunting. And of course, to the extent there's something fishy, so to speak, thank you to the one person who laughed.
You've been waiting to use that one.
About that, of
You're
course,
off your game.
even where the legislature does something that this court views as unwise or maybe not a good policy judgment, that's the legislature's job. If they did something that the rest of us wouldn't do if we were writing these laws, the laws are as written. And that goes to a point that I wanted to address that came up in Respondent's case. Respondent asked a question rhetorically, why wouldn't the legislature define take? Shouldn't the legislature? have defined take? And of course, the answer goes back to another canon of construction. This court's case law makes clear that the derogation of the common law, we as a court, or we as officers of the court, so to speak, we won't assume that the legislature intended to change the common law, only, or even by implication. If the legislature is going to change the common law meaning of a word, it must do so clearly and explicitly. It didn't even do so here by implication. The common law definition of take was left intact, and it's what the legislature has used throughout these statutes. It has never used take and taking interchangeably. And again, there's a functional reason for this, why the legislature would choose to have one word refer to all parts of the hunt that the commissioner may
Explain
regulate.
to me again why the legislature didn't use the two interchangeably in subdivision 4 of 301.
So at the top, so to speak, of subdivision 4, that second sentence says the commissioner shall prescribe the conditions for taking additional deer, including. So
Well, but the first sentence says the commissioner may, by rule, allow a person to take
Correct.
more than one deer. And then it goes on.
So that first sentence, so it is effectively speaking to a bonus tag and party hunting to an extent. The commissioner may allow a person to take more than one deer. So some hunters in season can take and possess. At the end, they'll have 2 deer at the end of a hunting season. But the second sentence is broader. It says the commissioner, it doesn't use the word also, but I'm going to insert it to make the argument. The commissioner also shall prescribe the conditions for taking additional deer. So that gives the commissioner 2 powers, essentially. The first power is to say, you, commissioner, you may allow people to take more than one deer. And oh, by the way, you can prescribe the conditions for taking. So it's not simply allowing the commissioner to tell a citizen, you get an extra deer, you get an extra deer, you get an extra deer. It's also saying you can regulate the time, the place, the manner, hours of day, hours of shooting. It's giving the commissioner that broader regulation to govern pre-take and post-take conduct for those people who are allowed to take an extra deer. So they're not interchangeable. When the legislature uses taking there, it's a broad grant of authority, and when it uses take up above, it's being precise. And of course, if they were interchangeable, and if take and taking and pursuing, if all these words, we just say, they're all the same, it's good enough, then if that were the case, the statute would allow the commissioner to, the commissioner may allow a person to pursue more than one deer. But we all know that hunters can pursue and do pursue more than one deer. That happens. And that the practice in this state is until you've taken your first deer, you continue to pursue deer the entire time it's allowed.
Just to be clear, under your definition, if somebody's out, same situation as the facts alleged here, but they shoot a deer, the deer dies, they can't find it, they're not guilty under the statute.
So if they don't acquire possession or control, they're
Yeah.
not guilty under this statute. There are DNR rules to speak to that, and the rules have probably gotten enough play here. The Chief Justice, Your Honor, you mentioned, I believe, baiting, putting food in a field or on your property.
Well, I didn't call it that, but...
I stand corrected. But of course, there's a separate prohibition on baiting. So even in that example, the concern, to the extent it exists, that this statute might not capture all the type of baiting that we wish to, that discretion and flexibility is, of course, left to the DNR commissioner. I've covered all the points I wish to cover. Unless any of your honors have any questions, I'll close briefly.
All right.
I'm going to end sort of the way I began. Every citizen in Minnesota, even those accused of crimes, are entitled to be charged under a statute that fits their conduct. And the rule of lenity, as well as other rules, tell us that close enough isn't good enough when it comes to convicting people of crimes. Please reverse.
Thank you, counsel. Thanks to both counsel for the help that you provided to the court. This matter is submitted. We'll issue an opinion in due course. We're going to recess now and step off and take off our robes and come back out and talk with the students. Before we do that, though, I want to thank the attorneys very much for coming on this roadshow with us. Everyone, please, let's thank the lawyers for their great job. We're in recess.
Folks, take a couple minutes to stretch, and we'll reconvene here.